If not, does everyone approve? Yes, okay. Alexi, your back is turned to me. I'm assuming that's okay. And then on the Liberal side? Yes, we're good? Okay. All righty, agreed. Thank you so much. Thank you. Thank you. It's really 5,500 for the actual study, but thank you. All right, so we turn our attention to what we are all here to do today, which is clause by clause of Bill C-3, an act to amend the Citizenship Act 2025. Pursuant to the order of reference of Monday, September 22nd, the committee is resuming its study of Bill C-3, an act to amend the Citizenship Act 2025. I would now like to welcome the officials available to answer questions today during the clause by clause. Please join me in warmly welcoming from the Department of Citizenship and Immigration, Uyen Hong, Director General, Citizenship Branch, Stephanie Jetosh, Acting Senior Director, Citizenship Legislative Policy, Alain Laurentiel, Team Manager and Senior Counsel, Legal Services Unit. I'm glad we have a lawyer with us. Alison Bernard, Senior Policy Analyst. Yes. And Jody Dewan, Senior Policy Analyst. Welcome to all of you. Thank you for being here with us. I would like to provide members of the committee with a few comments on how committees proceed with the clause-by-clause consideration of a bill. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the package each member received from the clerk, with a couple of exceptions, which we will talk to in a minute. During debate on an amendment, members are permitted to move sub-amendments. Only one sub-amendment may be considered at any one time, and that sub-amendment cannot be amended. Once every clause has been voted on, the committee will vote on the title and the bill itself, and in order to reprint the bill the bill may be required if amendments are adopted so that the House has a proper copy for use at a report stage. So I think with that, I am going to start with Clause 1, and I believe that Ms. Rempel-Gardner actually has an amendment that she would like to introduce. Ms. Rempel-Gardner.
Yes, and Chair, the clerk has this amendment in both official languages and will distribute it to colleagues. As well, just for my colleagues opposite, we made a slight change to two of our amendments which are similar that deal with age. He'll also be distributing those. And we also have hard copies in both official languages for consideration as well too. So those can be, that's fine. Yeah. All right, so Chair, I move that Bill C-3 in Clause 1 be amended by adding after line 9 on page 2 the following. 4.1, subsection 3.2 of the Act is replaced by the following. 2, paragraph 1A does not apply to a person if, at the time of their birth, neither of their parents was a citizen, lawfully admitted to Canada for permanent residence, or a protected person under the Immigration and Refugee Protection Act. So I'll briefly outline my rationale as this is being distributed. So this Bill C-3, the bill before us, fundamentally alters how citizenship by descent is applied to Canada. And the reason why I have approached or proposed this amendment is because a decade of the Liberals' high levels of immigration have profoundly altered Canada's immigration system and the landscape around it. In this context, Canada's unrestricted jus solis policy, the granting of citizenship to anyone born here, even temporary residence children, presents several major problems. For starters, the status quo presents obvious challenges as immigration levels have outpaced housing, healthcare, and job growth. This has led to social tensions, but the problems go far beyond these concerns. For a decade, the Liberals have operationalized the philosophy of post-nationalism, asserting that there is no shared Canadian identity, while simultaneously bringing newcomers in at a rate where integrating them into Canada's social and economic fabric has become challenging. The result of this coupling of misguided policy and poor management of the immigration system has led to the breaking of Canada's long-held immigration consensus and confusion over the responsibilities associated with Canadian citizenship. Anti-immigrant sentiment is also shamefully on the rise, as Canadians mistakenly blame those who recently came to Canada instead of the Liberal government's abysmally broken post-national immigration system. I'm almost done. These post-national Liberal policies have sent a message that there is no need for Canadian citizens to defend shared Canadian pluralistic values, like freedom of conscience and religion, freedom of thought and belief, freedom of association, and the equality of men and women. These practices have also virtually eliminated the expectation that anyone seeking to become a Canadian needs to abandon any violent, extreme, or hateful prejudices they once may have held and to contribute to the nation. Said differently, colleagues, the government has, through a post-nationalist and large-scale or mass immigration policy, brought into question the intrinsic value of Canadian citizenship. And without immediate reversal, this philosophy risks permanently breaking Canada's peaceful pluralism and long-standing consensus for immigration. And so you have the amendment before you today. This is why I've moved it. Today, there are millions of people living in Canada on temporary visas, comprising an astonishing 7% of the country's population, a situation never before seen in Canadian history. There are another estimated 500,000 undocumented persons living in Canada too, as well as 300,000 people in the asylum queue, many of whom will have bogus claims. Many of the millions of temporary residents are set to have their visas expire or have already expired. In this context, colleagues, it's not much of a stretch to foresee that Canada's practice of having no restrictions on solely citizenship acquisition is likely to be abused by people seeking to stay in the country after their visa expires or after a bogus asylum claim is found to be invalid. This is because while having a child on Canadian soil theoretically grants no immediate stay rights to parents who are temporary residents, in practice, court rulings, a deeply broken asylum system, protracted appeals, and sluggish deportations functionally allow them to remain. Recent videos, especially one circulating over this weekend on social media advertising this loophole, suggest this may be the case. The number of people born in Canada to temporary or undocumented residents is not publicly tracked, but recent policies by Canadian hospitals charging temporary residents for giving birth suggest it is a problem. And birth tourism, the practice of non-residents, for example, those on visitor visas, traveling to Canada to have their child on Canadian soil so that they can obtain citizenship, is also on the rise. When former Prime Minister Stephen Harper left office in 2015, birth tourism levels were 590% lower than they are today. Birth tourism is now at its highest levels ever, both in terms of absolute levels and percentages. These types of population growth are not accounted for in immigration levels. In this context, Canada is an outlier by granting unconditional birthright citizenship and should move into alignment with peer nations like the UK and Germany, which are also experiencing unprecedented immigration crises. And what I've in front of you today, colleagues, is to restrict birthright citizenship to permanent residents, at least one person being a permanent resident, one parent being a permanent resident or a citizen. This would align Canada within other peer nations and would somehow, I don't support Bill C-3, but it could restore the value of Canadian citizenship that has been eroded over the last 10 years. Colleagues, without changes to the current unrestricted system of birthright citizenship, as well as the federal government's relatively porous border policies, Canada risks inviting further organized birth tourism and immigration fraud, as well as further clogging an overwhelmed processing and appeals pipeline. Being a Canadian should mean someone to something who acquires it, and that meaning should be derived from significant enough ties to our nation that a deep understanding of responsibilities associated with being Canadian becomes joyfully entrenched within a new citizen's fiber. Canadian immigration law and policy should vigorously protect that principle and not erode it. I think that scrapping the bill in front of us would be a good place to start, but it needs to be severely amended, and we are going to be proposing other smart amendments to this bill to protect the value of Canadian citizenship today. But folks, the decade of unfettered mass immigration, the further erosion of the value of our citizenship through bills like this, and an entrenched and operationalized post-nationalist viewpoint from this government has led to a lot of people not understanding what being a Canadian is And frankly, we see that in the Minister of National Identity. The Minister of National Identity said, there's no one way to be a Canadian. He didn't talk about respect for rule of law or protecting democratic institutions. And we have a former Prime Minister who said that Canada is a post-national state. The current Prime Minister only could define Canada as not being American. And if these are the leaders of our country, we have a problem with how we obtain citizenship. So if C3 is to proceed, I believe that we should proceed by restricting birthright citizenship to one parent, at least one parent having permanent residence or citizenship, and move ourselves in alignment with other peer nations. Thank you.
Thank you so much, Ms. Rempel-Garner. The amendment is admissible. I just want to mention that to everyone. Monsieur Brunel-Duceppe, c'est à vous.
Oui, merci, Madame la Présidente.
Thank you, Madam Chair. I would vote against this amendment. This is a principle that we have to keep in our society in Quebec and Canada, and unfortunately, I see a Trumpian idea in this conservative notion. So I want the committee to know in advance which way I was going to vote.
Merci. Does anybody else want to address this amendment?
We'll be voting against, Madam Chair. We're ready to vote.
Okay. No one else wants to speak to this? Great. Okay. So now we move to. We now go to vote on Clause 1.
Shall CPC 10.1 carry? Should the amendment carry?
Okay. Should the amendment carry? Should we go to vote person by person, or should we do yes or no per side? What do people want to do?
I think it's easier to go.
Okay, recorded vote is easier, you guys, so let's just do that, please. Can we please do a recorded vote?
So on the amendment proposed by Ms. Rempel-Garner, Mr. Fragiskatos,
No.
Ms. Soudi,
No.
Ms. Zaid,
No.
Monsieur Zubiri,
No.
Mr. Ma, Mr. Menegakis, Mr. Ridicott,
Yes.
Ms. Rempel-Garner,
Yes.
Monsieur Brunel-Duceppe. Yeas 4, nays 5.
Okay, the amendment is defeated. And now we are going to go to the next amendment, and if I can now turn again to Ms. Rempel-Garner for the next amendment.
And just, Chair, you're looking at CPC 1 as well? Okay. Fantastic. Okay. So, colleagues, I move that Bill C3 in Clause 1 be amended as follows. A, by replacing line 36 on page 3 with the following: 1,095 days during any period of 5 consecutive years before the person's birth, or B, by replacing line 28 on page 4 with the following.
Juste point out,
Sorry.
Madame la Présidente.
Oh, sorry.
Juste,
Point of order, Madam Chair. There's some confusion here with the interpreters. What they have is, I really want to be sure that they're translating what we have on the floor. Could you start over from the beginning?
Where we are at. Notre...
Oui, c'est juste qu'on était pas, on suivait pas nécessairement ce qui se dit.
We weren't necessarily following what Ms. Rempel-Garner was saying. I don't understand. Do we need a few minutes? Okay.
I wasn't confused for once. It was a strange thing. Okay.
Okay, Ms.
I'll start
Rempel-Garner.
again.
CPC 1. Thank you.
That Bill C3 in Clause 1 be amended. A, by replacing line 36 on page 3 with the following: 1,095 days during any period of 5 consecutive years before the person's birth, or B, by replacing line 28 on page 4 with the following: 1,095 days during any period of 5 consecutive years before the person's birth.
Point d'ordre, Madame la Présidente.
Point of order, Madam. The interpreters don't have the right text. I'm not the only one hearing this or listening. We have to make sure for everyone listening in French that we have the right text for the interpreters.
Or is it in the package, maybe?
That's the Official Languages Act.
For 1
Yeah,
minute,
there you
please, so that we could figure out where things are at. Back in session. And I think that our interpreters are now on side. And we apologize for any inconvenience. And thank you, Monsieur Brunel-Duceppe, for alerting us to the issue. So we are discussing CPC 1. And so, Ms. Rempel-Garner, would you mind starting from the top, please?
Okay. I move that Bill C3 in Clause 1 be amended, A, by replacing line 36 on page 3 with the following: 1,095 days during any period of 5 consecutive years before the person's birth, or B, by replacing line 28 on page 4 with the following: 1,095 days during any period of 5 consecutive years before the person's birth. So briefly, colleagues, the reason for this amendment is to ensure
Point d'ordre,
that...
je pense que c'est un point d'ordre cette fois-ci. Parce
Hold on,
que
point-
sur-
I think this is a point of order. Point of order. Yes, I think it's a point of order. Because in English it says 1,095 days, and what we have in French is 15 days instead of 1,095.
Substantive translation error. Yes.
Okay.
Yes, it's a big difference.
So shall we officially correct that en français to 1,000?
It's okay in the bill. It's okay in the bill. It's just.
I did not make that translation, just for the record, but
Okay, so I've been assured by our legislative clerk that it is correct in the bill, okay? That is 1,095 en français in the bill. Okay.
so that I am, just for clear, we want 1,095 days and any 5 years prior to the person's birth. So the reasons, colleague, for this, in the Citizenship Act, citizenship by naturalization requires this exact provision. And while there has been some assertion that citizenship through unlimited descent, as provided for through Bill C-3, is somehow not immigration, acquiring citizenship should, to maintain the intrinsic value of Canadian citizenship, should require significant ties to the country. The naturalization process, through the existing process set out in the Citizenship Act, defines that by a 3 out of 5 year period. So all we're seeking to do here is harmonize Bill C-3 with what is already in the Citizenship Act for citizenship by naturalization, so that we are not creating two classes of citizenship acquisition. That seems inherently un-Canadian to me, and I also foresee legal challenges if there's no harmonization on this component. Also, again, I just want to stress to colleagues, we should be, as a committee, trying to ensure that government legislation protects the intrinsic value of Canadian citizenship. We feel that this requirement, the amendment would strengthen that, but it would also allow for persons to, not be stuck in the country for an extended period of time. There's flexibility if somebody has to go to a funeral or something like that, or an emergency comes up. But there has to be a demonstrated concerted effort to stay in the country over a period of time in order to pass down citizenship. And just colleagues, I want to remind colleagues that while the courts did make a decision on this, the government chose not to appeal that ruling and then drafted this legislation. The government chose to put this legislation in front of us. So this is an amendment that will harmonize the provisions for citizenship acquisition through C-3 with what is currently in the Citizenship Act for acquiring citizenship through naturalization. We think that that is only fair for other classes of immigrants who seek to acquire Canadian citizenship through naturalization. Thank you.
Thank you, Ms. Rampel-Garner. Anyone else want to speak to this amendment? Mr. Fragiscatos.
Thank you, Madam Chair. In fact, I'd like to ask officials their view on the consequences of this and what this would, the implications, consequences that even include unintended ones. That's a general question to whoever wishes to take it.
Thank you for the question. So Bill C-3, as you know, is written in a way that would allow Canadian parents who gives birth abroad to be able to pass on citizenship to their children beyond the first generation, as long as they can meet a substantial connection requirement of 1,095 days cumulative any time before the birth of the child. It is viewed that with this flexibility, there is recognition that Canadians living abroad can maintain a strong connection to Canada and have the flexibility to make decisions accordingly for their families, and that by restricting this time frame, you may create a new cohort of lost Canadians. And you may also exclude Canadians who have spent more time than 3 years cumulatively in Canada, but over a longer period of time.
Thank you. Mr. Fragiscatos.
Go over those 2 points again. A new cohort of lost Canadians. Start there, and then I have a question on what you just summed up there in terms of the time frame and what sounds like an unintended consequence. But begin with this new cohort concern.
My apologies, I forgot to turn off the mic there. Thank you for the question. So when we say that potential unintended consequences could lead to the creation of new lost Canadians, is because there are cases whereby children who come back over the years, families living abroad, They have children outside of Canada, and they come back to Canada over the years, visiting grandparents, having connections with their families here in Canada, and they may not spend 1,095 days within a consecutive 5 years. And by putting that tight limitation on them, you may then exclude them from citizenship from descent, or being able to pass on citizenship to descent for their children. And that's what we mean when we say you could create a new cohort of lost Canadian.
And with that, Chair, I'll just continue. Legal challenges could potentially arise. Is there a view on how that might be interpreted by the courts? You create a new cohort of lost Canadians, rather. I would think that this would raise serious legal implications.
I mean, it's always open to people to bring a challenge on charter grounds, but the position of the Department of Justice on the bill as it stands now with the requirement is it is in line with the charter.
Thank you. Oh, go ahead, please. Oh, okay. On the time frame issue, your second real concern, it sounded like substantive concern. Could you go over that one more time?
The difference between what is being proposed and what is in the bill is what's in the bill is any time before the birth of the child. A child who is born beyond the first generation, as long as the parent can meet the substantial connection any time before the birth of the child, versus the qualifying time frame. The proposed amendment is suggesting that the person would have to meet 1,095 days. It could be cumulative, it's not consecutive based on the proposed amendment, but it has to be within a consecutive 5-year period. So that can restrict somebody who may actually spend more time in Canada, but not within a 5-year period.
Thank you, Mr. Frederick-Skatos. Mr. Redcop.
Thank you, Madam Chair. So I just wanted to point out that listening to the official's description of this, what you said, I believe, if I paraphrase you, was your example was a family comes to Canada multiple times, but not enough to qualify for 1,095 days in a 5-year period, which to me sounds like, and you suggested, or Mr. Frederick-Skatos is suggesting that could be a new cohort of lost Canadians. And to me, what you described as somebody who comes to Canada multiple times but not 1,095 days sounds like a perfect description of a visitor to Canada. So I just wanted to point that out.
Thank you, Mr. Redcop. Any more debate on this amendment? Mr. Frederick-Skatos.
So talk again, if you could. If you look at the amendment, one could argue that there's reduced flexibility in, if you compare the amendment to C3, and what the implications of that reduced flexibility would be with regards to the Citizenship Act and the need for consistency that the Ontario Court of Justice has talked about.
I won't speak to the Bierquist decision per se, but from a policy perspective, it was decided that 1,095 days was aligned with the Citizenship Act in terms of how someone could demonstrate a connection to Canada. And given that there are people who, recognizing just the way Canadian families live today, that it was designed in such a way to give them that flexibility to live their lives abroad and continue to maintain a connection to Canada.
In your view, does this amendment create a new misalignment, perhaps? Or whoever wishes to take it.
I think this amendment is not aligned to the bill, but that's as far as I could say.
Thank you, Mr. Frederick-Skatos. I now have Monsieur Brunel-Duceppe.
Merci, Madame la Présidente.
Thank you, Madam Chair. Just a brief question. What I've understood when we had witnesses before the committee, that 1,095 days as criterion C3, that number of days was taken as a model in the Immigration Act so that permanent residents could be naturalized Canadian. So 1,095 days was taken by officials as a model for C3. At that point, in the Immigration Act, it's over a period of 5 years. What this amendment does is that it continues this, but it takes the whole model and what was been done by the officials. I fail to see how this can be seen as unconstitutional, since the period of 1,095 days comes from the Immigration Act. So logically, the period of time that applies in C3 would be from the same model, and everybody should be happy. Am I wrong?
Question. The reason why you're right in the sense that we chose the same number of days, 1,095 days, but the main difference is to receive a grant of citizenship, you would have to meet 1,095 days within the last 5 years before your application, versus Bill C3, it is proposing that it would be any time before the birth of the child. And the reason why we took this approach is because we are talking about citizens by descent. They are born to Canadian parents abroad. So versus the grant approach, the grant pathway, we are talking about foreign nationals who become permanent residents who pursue citizenship to become Canadian citizen here in Canada. So given that there are two different pathways, one where we're talking about born to Canadian citizens versus foreign nationals who become permanent residents, there is that additional flexibility to allow Canadians living abroad to pursue the opportunities and the lifestyle that they wish in order to, while knowing that they can still maintain a connection to Canada.
Une dernière chose.
One last thing, Madam Chair. You're saying that these are two totally different things. So why have chosen the 1,095 days, taking that out from the Immigration Act? If these are two different things, why the same number of days?
We chose the 1,095 days to align with how we do it in the grant pathway, recognizing that it is a sufficient number of days in order to demonstrate connection to Canada.
Thank you, Ms. Huang, and thank you, merci, Monsieur Brunel-Duceppe. Anyone else want to weigh in on this amendment? Mr. Fragiscatos.
Thanks, Chair. Can I just ask again about I just want to ensure that the question is put forward on this amendment and the Citizenship Act. Is there anything in this amendment that would create either a misalignment or an inconsistency between what's called for here and the Citizenship Act in terms of requirements, so that you have potentially an argument about different treatment?
We would have to take that back and look into it further.
It seems to me that that's a pretty big issue if we pass an amendment that could potentially create an inconsistency. I don't know if colleagues have views that they wish to. We might have some lawyers in the room as well.
I think, Mr. Fragiscatos, I think we already heard that it's constitutional.
No, that's not the argument.
Okay.
That I'm putting forward, Madam Chair. Oh, perhaps your argument, yes, I understand what you're saying, but my specific question relates not so much to constitutionality as it does to ensuring that there is consistency between the amendment and the Citizenship Act in terms of requirements.
Mr. Erskine-Smith, did you want to weigh in?
I just had a question, because I think Brad made a good point just about examples being illustrative. And so just so I'm clear, if this amendment were passed, say I, born in Canada, lived in Canada my whole life, and then I go off to study, and I study for a period of, say, 3 years abroad, and I have a kid I meet someone, I have a kid abroad, I wouldn't have then been resident in Canada within a period of 1,095 days over 5 years. Like, walk me through, like, examples like that might be illustrative in terms of, like, people studying abroad, having children abroad, but they've been in Canada their whole life and just passing citizenship on in that context.
So the starting point would be that both the parent would have been born abroad, and then you're the next generation that's proceeding to give birth or adopt abroad. give birth in this situation. The way we have understood the amendment, as long as the individual has spent 1,095 days within any 5-year period, consecutive 5-year period prior to the birth of the child.
Thank you. Anything else, Mr. Redekop?
Thank you, Chair. Just a response to what Mr. Frederick said, and it kind of echoes on what Mr. Brunel Decep also said. Consistency is important, and I think that's exactly why we're making this amendment, because the Citizenship Act already has 1,095 days within 5 years, and this C3 only has 1,095 days. So I think we can make a pretty strong argument that it's becoming consistent, as Mr. Frederick asked for, by putting the within 5 years component of it, and then it's aligned with other segments. So thank you.
Thank you, Mr. Redekop. Anyone else want to enter this debate? Okay, so seeing none, shall CPC 1 carry? Yes, we're going to vote. Mr. Clerk.
So CPC 1, Mr. Fragiskatos.
No.
Ms. Sodi. Ms. Zaid.
No.
Monsieur Zubiri.
No.
Mr. Ma. Mr. Minigakis.
Oui.
Mr. Riddickop.
Yes.
Ms. Rempel Garner.
Yes.
Monsieur Brunel Duceppe.
Oui.
Yeas 5, nays 4.
The amendment carries. Okay, next we are going to Liberal 2. I think we have Mr. Erskine-Smith who is going to speak to the amendment.
I think I'm substituting for Mr. Zuberi. I'm substituting for Ms. Zahid while I'm doing this. So this takes us in a different direction, and I move. This is for reference, folks. It's 13626.156 in the package, Lib 2 in the package. And I move, there's going to be one small change that I make, and I'll explain as I get there. But the Bill C3 in Clause 1 be amended by adding after line 28 on page 4 the following. So 8.1, so Section 3 of the Act is amended by adding the following after subsection 3, a new 3.1. Subsection 3 does not apply in respect of a person who, while a minor child, was adopted before or after the day on which an act to amend the Citizenship Act came into force by a citizen, if the adoption is recognized by the province or territory in which the adopted parent resides. This is the change, by the way. It's and was in accordance with the Convention on the Protection of Children and Cooperation in respect of intercountry adoption that was concluded on May 29th, 1993, and came into force on May 1st, 1995.
Thank you, Mr. Erskine-Smith, but my copy says in which the adoptive parent resides on was in accordance. You're saying and was in accordance.
So
Thank you.
The text said or,
Okay.
but the amendment I'm moving is and.
Perfect. Okay, thank you. Okay, debate. Who would like to speak to this? Oh, Mr. Erskine-Smith, thank you.
Might as well kick it off. So I want to lay out the rationale in greater detail, but I just want to say personally, so I have two constituents who are affected by this that have adopted abroad. They brought this to me years and years ago, and I made a personal commitment to them that when this issue arose, there was an opportunity to correct this, that I would do so. I'm not a member of this committee. I'm visiting for this specific reason to get this specific concern addressed. And the concern is this, that their kids, whose only citizenship is Canadian, whose only real connection is to Canada, will be treated differently than my kids, okay? I think there's an unfairness to that, and I want to walk through that unfairness. First, I'll read a letter from one of my constituents who says, families who are formed through the process of adoption are required by law to complete all of the necessary regulatory milestones to become a family and secure citizenship for their children. These stringent and arduous requirements are enforced specifically for adoptive families who adopt while living, working abroad, and for Canadian families who adopt internationally while living in Canada, the majority of adoptions. Fundamental to this process already is parental attestation that our children will be raised as Canadians. And I want to get specifically in greater detail because these are provincial processes and territorial processes. And so just to be clear, these are parents who, according to the rules as they are set down by provinces and territories, have to be living in Canada and commit to raising their children in Canada. And I just want to be especially clear, this was provided to me by a constituent of mine who adopted a child from Zambia. They had to confirm their residency in Ontario. They had to complete a home study by an approved licensed adoption practitioner in the province of Ontario, which consists of, and I'll just say a few things, multiple home visits to inspect our Canadian home where the child will live, detailed interviews with both parents as to how they will ensure their child is integrated into Canadian life and how they will support them, acquire multiple reference letters from other Canadians who can vouch for their ability to parent, complete child welfare checks in every province that they've lived, in every country they've lived longer than 6 months. They have to be approved from the Ministry of Ontario as adoptive parents, after which then they wait in the referral program. And upon returning to Canada, they were required to complete 3 years of home visits by a licensed Ontario social worker in their home. Okay, so every province and territory gives effect to what's known as the Hague Convention on Intercountry Adoption. And the idea there are many ideas there, but one of the ideas there is that kids adopted internationally have the same rights as kids adopted domestically. And let me read specifically from the Hague Convention. This is Article 26, the Hague Convention on Intercountry Adoption. In the case of an adoption having the effect of terminating a pre-existing legal parent-child relationship, the child shall enjoy in the receiving state and in any other contracting state where the adoption is recognized rights equivalent to those resulting from adoptions having this effect in each such state. Let me go on to say, this is not new. This was studied by this committee in 2009. The committee says a number of adopted parents, the committee is of the opinion that adopted children should not be treated differently from children born in Canada. The committee recommends that the Government of Canada grant children adopted abroad by Canadian parents ordinarily residing in Canada the same legal status as children born in Canada. And I note that that same committee also took issue, by the way, to say that this substantial connection test that we're debating right now, the committee also recommended a version of that alongside this specific change that I'm advocating for. This was recently studied briefly, I should note, by the Senate, but Senator Arnott, who, by the way, was a judge, a Crown prosecutor, a lawyer, he was the chief of the Human Rights Commission in Saskatchewan, he has called his proposed amendment, which in substance is the same as I'm proposing here, children who receive citizenship after their adoption is complete should be exempt from the substantial connection test. Now, it's not only in Canada where legislators have recommended this, in the UK. So I mentioned the Hague Convention obligates us. We would be offside the Hague Convention should we not adopt this amendment. But the UK and like-minded countries, but I'll zero in on the UK. The UK's rule is if the adoption is made in accordance with the convention, at least one parent is British, and the adopting parent is resident in the UK, the child will automatically become a British citizen other than by descent, which is the same as if they had been born in the UK to a British citizen parent. So again, that's exactly what, if this amendment were adopted, that would be the rule here in Canada. Civil society, and let me move to, let me see if I can find my notes here, but I'll just run down. So civil society wrote to then Minister Miller in support of Senator Arnott's proposal, and they said, and these are adoption experts at the Child and Youth Permanency Council of Canada, the Adoption Council of Ontario, the Adoption Options Alberta and Manitoba, New Brunswick, Adoption Foundation, and more. And I just want to be clear about the problem that we're seeking to solve through a substantial connection test. The idea, of course, and I actually take the point that Ms. Garner's amendment to make sure there is some stringency to this, right? Where you don't want a situation where you have someone who is born abroad, lives abroad their entire life, has no connection to Canada, and perpetually passes on Canadian heritage. I get that. And then even the more stringent proposal that I know Alexi supported and Michelle had put forward, I get it. Because, again, you're trying to establish an actually real and substantial connection. Brad, you said we don't just want visitors. Well, here's a situation where it is impossible to adopt via a province, and again the amendment specifically speaks to the adoption is recognized by the province or territory in which the adoptive parent resides and was in accordance with the Hague Convention, it is impossible for there to not be a real and substantial connection when someone is adopting through a provincial or territorial agency because they are already obligated to reside here and to commit to raising their child here, and the amendment would ensure that my kids are treated the same as theirs and are not discriminated against, and their kids are not discriminated against and treated as other than my own. Thanks.
Thank you, Mr. Erskine-Smith. Mr. Redcott.
Thank you, Madam Chair. Thank Mr. Erskine-Smith for this amendment. I think, personally, I think it is important that we make sure that adopted kids are treated the same, as you put it, the same as your kids. And I think on this side we would have the same perspective. My concern with this, though, is, I guess years of working on this committee and watching changes go through the Citizenship Act, it's always what are the flaws, or what are the holes, what are the, do we create new problems? And so in this light, I think about there's a lot of human trafficking going on right now, and so a person can travel to a continent of Africa and potentially find somebody. And may not even know that this little child has been trafficked, and so that's obviously something we don't want to be encouraging and supporting. And so I guess my question to you is, should we be concerned about that? Is there anything in here that would help to prevent that from happening, and how might we be able to deal with that? Because I believe we should be, as you say, changing things to make adoption more equal to birth. In that case, I agree, but I'm concerned about potential downside of this, and the ways that, most importantly, the ways that unscrupulous people who are always out to make a buck will find a way to abuse the system, which we've seen in so many cases here with the way that the Liberal government has set up the immigration system, whether it be students or temporary foreign workers or others. There's always people who are going to be able to exploit the system that you set up. So how are you going to protect against that?
Mr. Erskine-Smith.
So I don't want to discount a concern around, maybe you've heard testimony at this committee around human trafficking via adoption. That has not been flagged for me by the adoption community itself. Having said that, I don't want to discount the concern without knowing the evidence. I will simply say this. I respect provincial and territorial authority to manage the adoption process. We are not litigating the province's stringent rules. Provinces can put in place stringent rules to ensure they're taking action. I listed off in Ontario. I'm sure in Quebec they have stringent rules as well, where adoption agencies are subject to provincial regulations. I set down just one example, but I could have pointed to others where there are multiple visits. There's multiple checks. There's multiple investigations as to attestations from others in the community. All of that is within provincial authority. All I am saying is kids should not bear the brunt of any of these concerns. And there are hundreds of kids, there are thousands of kids in Canada today who are internationally adopted. This is not a huge. I don't want to overstate the issue. The last I checked, the department would have better numbers, but the last I checked, there are, the last year that I saw numbers, it was under 700. Less than half of them are by direct grant. It's not. I'm not suggesting this is a huge issue, but any inequality as between an internationally adopted kid and a kid adopted here in Canada or born in Canada, I think is unconscionable. We should address it. And where there are human trafficking concerns, where there's evidence of that, we should be working in tandem with the provincial agencies and territorial agencies that have that jurisdiction and authority to address those challenges.
Thank you, Mr. Erskine-Smith. Ms. Rempel-Gardner.
Thank you. To the officials, did you provide the minister with any advice to include this type of an amendment in Bill C3?
We provided analysis of this amendment. If that answers.
Prior to today's, you receiving notice of this amendment, did you provide the minister in the drafting of C3 any potential, or sorry, any advice to include this type of content?
There was analysis in terms of the Citizenship Act and the framework for adoptions. And so, as you know, the structure of Bill C3 is to mirror as much as possible for the adoption cohort. So in other words, those who are adopted abroad beyond the first generation, as long as their parent can meet a substantial connection requirement, they would be able to have access to the direct grant 5.1. And this is talking about those who are adopted on or after the coming into force of the bill. And those who are adopted prior to the coming into force of the bill would be able to have access to the direct grant 5.1 without having to meet a substantial connection requirement. And the reason why this was put in place the way the bill is structured is to align the two cohorts of those who are born abroad to a Canadian parent with those who are adopted abroad by a Canadian parent.
So, said differently, it was a purposeful decision to not include this particular structure within the bill as it was drafted. Would that be a correct characterization?
I would say that's the correct characterization.
So just to be clear, it's the minister made a decision not to include this in this bill at the advice of the department due to the harmonization and other considerations that you just raised. Is that correct?
Well, we provide advice, but really, yes, it is the minister who takes the decision in cabinet. Yes.
We didn't hear, this is now, I wasn't on the committee listening to it last time, but it has come up in various provisions. I haven't heard any testimony either from the minister or other witnesses to date suggesting that this is needed. I'm just going to assume that the minister didn't include it in the revised draft due to advice. I guess I'm going to ask a couple more questions just with regard to what my colleague said. We all have, as members of Parliament, casework that comes into our office, and the most difficult cases are often adoptions. And they're often, I've had a couple in my tenure as an MP where I've had a couple who have gone abroad to adopt a child. They've worked through what they consider to be legitimate agencies. They've gone through all the processes. And then there's questions about the child's parentage and whether or not the child is who they say that they are, or if they've been, for lack of a better term, trafficked. Those are the most heartbreaking cases because it hurts everybody, right? In those cases, it's very difficult for the minister, for the Canadian government to intervene, because on one hand you have a couple who has formed an attachment to a child, and on the other hand you have a family who's had their child trafficked, and in the middle you have a child. So what I worry about, if we move this with no testimony, the minister hasn't said that this is needed, and essentially outside of the advice of the department, is that we are going to create a potential situation where a child that could be human trafficked might automatically get Canadian citizenship, which creates a very difficult diplomatic situation. Would that be a correct concern to be worried about?
So when a parent who is adopting a child access the 5.1 to seek citizenship for that child, the department does conduct an assessment in accordance to the Hague Convention. And part of that assessment is to be satisfied that adoption meets the requirements of the Citizenship Act before the adopted person can become a citizen. So some of those criteria include it being in the best interest of the child, created a genuine parent-child relationship. This was done in accordance to
Could I just interject, though? With all due respect, the screening processes within citizenship and immigration lately have been somewhat suspect. I mean, I was just up in the House of Commons talking about a case where a man who was on the UK's registered sex offender list was allowed into Canada. I think that this potentially just granting Canadian citizenship to automatically without hearing the minister and knowing that there are significant screening processes in CIMM, within the Immigration Department right now is a concern. I don't have confidence that the department can manage these situations and that there could be a diplomatic situation. And the other thing for colleagues, just to say, is we have not had the minister or other witnesses speak to these very real concerns here. I think that if the member who is, I appreciate him being here and taking interest in the bill, who is, not a permanent doesn't come to all the meetings would like to put a private member's bill for, or make these cases with GAC officials, with international adoption agencies, looking at these harder cases and trying to figure out safeguards, I would be open to that. But I think that trying to amend a bill where there could be significant consequences outside of the advice that the department provided to the minister, and after the minister made a decision not to include this, is problematic. So I understand where his heart is at, but I think it probably would be prudent for members on this committee to take a step back, ask for a bit more information, and perhaps he should table a private member's bill to this regard as opposed to moving it at committee here. Thank you.
Thank you, Ms. Rempel-Garner. Thank you, Ms. Hoeing. Monsieur Brunel-Duceppe.
Thank you, Madam Chair. I have two brief questions. For the officials, do we have a figure about how many people this could affect if we were to adopt this amendment?
I will then pass it to officials, because it is tracked. International adoptions are tracked. They were higher in 2010, and as I say, the last year that I saw, I think it was 2022 or 2023, we're talking like it was under 700, the number that I saw, and less than half were by direct grant, which is really what we're talking about here. And I just want to emphasize that, because Ms. Rempel-Garner is seeking to basically litigate inter-country adoption wholesale. That's not what it is, because what we're talking about is there's an argument that because human trafficking might be part of inter-country adoption, therefore what we shouldn't do, and because let's talk about what we're actually doing. There is already citizenship that is granted to kids who are adopted. That's not what we're talking about, right? So the concern that there's some automatic granting of citizenship to the adopted kids themselves, that already happens once they go through the rigorous steps and I've outlined some of them. That's not what we're litigating here. What we're arguing about here is the rights of those children, whether the children themselves are treated as fully Canadian to then pass their Canadianness on to their kids. That's what we're actually litigating here. And why, of all the concerns, if you got concerns about human trafficking, why impose the punishment on the kid who the only life they know is Canadian? That is bonkers to me. And the last thing I'll say is, for someone who just overruled officials with an amendment that I actually think makes some good sense, the idea that the officials' advice here should be tantamount, should be paramount in all that we listen to. Let's listen to the adopted, the families who are directly affected here. Let's listen to, and yes, Parliament has weighed in on this. This committee weighed in on this in 2009, as I mentioned, after studying the issue. I encourage, if you want me to pass around the committee report, I'm happy to. But this has been studied by this committee. There is no reason we should differentially treat kids who are subject to international adoption. They are as Canadian as the rest of us.
Thank you, Mr. Erskine-Smith. We're going back to Monsieur Brunel-Duceppe, who had two questions. Please go ahead.
My
question is a simple one. I find it unfortunate that this has become a debate like this. Both members of Parliament are acting in good faith. Nobody should attack anybody else on this issue. I think Ms. Rempel-Garner is acting in good faith, has a big heart. She's thinking about certain children who are victims of human trafficking. I don't think it's proper to criticize her. So why didn't the government propose this in C3 directly? We're looking at the amendment. I think the Conservative question is a legitimate and good one. And my first question is about the number of people affected. Is that the correct number the member told us? 700 people who might be affected if this is adopted?
Please order, please. Okay, Ms. Hoeing.
I have statistics that for the last 5 years, out of a total of 3,440 individuals who were adopted as minors, 2,055 of whom were adopted in Canada, meaning the parents were residing in Canada, which is the cohort that Mr. Erskine-Smith is referring to.
And if we were to adopt this amendment, would the adopted child have to respect the same number of days, that 1,095 days, in order to pass down citizenship, or am I misunderstanding the amendment?
Specific amendment, when we looked at it, as currently drafted, this amendment would actually have no effect because in actuality, it would not apply to anybody. The amendment modifies subsection 3.3 of the Citizenship Act. That part of the act refers only and specifically to citizens by descent and not adopted citizens. However, the proposed amendment only refers to and only affect minor child adoptees. So in other words, any person who is an adoptee citizen is not subject to subsection 3.3, which only applies to people who are born citizens by descent. Therefore, the amendment is contradictory and would not have any effect since it cannot apply to anyone. There is a presumption that legislative provisions must have meaning. Intentionally amending the Citizenship Act to introduce a provision with no effect could have unpredictable and unintended consequences.
Si vous permettez, c'est sûrement
If
moi
you'll
qui...
allow me, I probably expressed myself badly. This is all very complicated. I'll try to simplify my question as much as possible. If we adopt Mr. Erskine-Smith's amendment, will the children concerned by Mr. Erskine-Smith would normalize that 1,095 days so that a person could then pass on their citizenship? Is that clear? You seem to understand. On your left, there's somebody who seems to understand. Yes, I understand. The point I want to underscore.
As drafted, there are no effect to the Citizenship Act. There are no changes to the Citizenship Act. We've analyzed it, we reviewed it. Why I understand Mr. Erskine-Smith may have an intention to change the act for adoptees, the way it is drafted has no effect.
Hold on, I do have Ms. Rempel-Gardner and then Mr. Menegakis, but Ms. Huang, are you saying that it would, the way it's drafted, and if it was we voted it in, it would not have the effect of doing what Mr. Erskine-Smith would like it to do? Okay, thank you. Okay, Ms. Rempel-Gardner.
Okay, so I just want to respond in case my colleague was giving his rant about me as a clip for his constituents. So to his constituents, I feel for you. I hope you're working well with your MP. But what we have here is a piece of legislation that the government has now twice put forward to Parliament. We have officials who are saying that this amendment is, I think the quote that I had could have negative unintended consequences and or might not work as it is. We've had no testimony with regard to how this functionally could impact various diplomatic situations. So, I just want to be very clear to somebody who may be listening to Mr. Erskine-Smith's misdirected rant. This is about legislators trying to get a very complicated piece of legislation right, and supporting a piece of legislation that I guess is redundant or could have unintended consequences. Like, this is not the way to go. So if they are listening, I would encourage them to talk to Mr. Erskine-Smith about tabling a private member's bill, which can go through proper diligence and review in order to get to the end result. Thank you.
Thank you, Ms. Rempel-Gardner. Mr. Menegakis.
Thank you, Madam Chair. And further to what Ms. Rempel-Gardner just said and what Mr. Duceppe said, I want to get a point across here. This is a bill that was copied. Bill C-71, that was Bill C-3. Basically, we changed the title, the government changed the title, presented the bill. This was a bill that was presented in the previous Parliament, was debated here at this committee at some great length, from what I understand. I was not here, where these provisions, Mr. Erskine-Smith was a member of the previous government as well. He's presenting this here today. I don't know if he presented it beforehand. You had an opportunity to discuss the bill in some length, I assume, with the minister. The minister did not deem it necessary to implement this particular amendment as a change to the bill that she copied, she cut and pasted. You have just testified before us that this bill will affect absolutely this amendment to the bill will affect absolutely no one. So I fail to see the benefit of even discussing this any further. This is a non-amendment. If Mr. Erskine-Smith, and I agree with Ms. Rempel-Garner, feels so inclined to make this, it's a very important issue for him, and to perhaps make it his private member's bill and speak to his government to somehow get on the order paper to ensure that he has an opportunity to do that, he can do that. But to just simply come here and posture for the sake of just perhaps who's listening for something that will do nothing to help the people that he is referring to doesn't appear to make any sense to me. Would you care to comment on that, or is that a fair assessment?
Again, just in terms of this amendment that is in front of us, I would say it has no effect, but depending on whether or not Mr. Erskine-Smith moves the other amendment, there would be effects to adoptees, that specific cohort. But perhaps I could turn over to my colleague, Mr. Laurencel, to explain to you why Bill C-3 was structured the way it is for the adoptees.
Would you like that? Would you like that, Mr. Menegakis?
No.
Okay. Okay, I think we have Mr. Erskine-Smith. Do you want to weigh in?
Yeah, so look, you'll see it's interesting when we're arguing about this amendment when the other amendment is also relevant because they're effectively aiming to affect the same change and covering all bases. And look, the lawyer who took the case and successfully won the case, I don't practice immigration law, so you go to the legislative drafters. I went to the legislative drafters, said I want to affect this change. They came back with drafts. They came back with certain advice. I consulted with counsel who are expert in immigration law. And I said, "Is this redundant? Is it not?" So the argument I got back was no. All I want to do is cover all the bases here. So just so we're absolutely clear, all of the arguments I've laid out, you're suggesting that this particular amendment is effectively unnecessary. And it's the second amendment to 5.1 sub 4 that would affect the change that I'm after.
Thank you, Mr. Erskine-Smith. Ms. Wang?
I'm going to refer it to my colleague Jody to elaborate.
Mr. Dewan. Ms. Dewan, sorry.
Thank you, Madam Chair. Perhaps if it may be helpful, I can explain in more technical terms why it is that this particular amendment is of no effect. That doesn't mean that any of the other potential amendments would be the same, but this particular amendment, I can explain why that happened, if you would like.
Ms. Dewan, is it possible for you to just answer the question as to whether or not the other amendment that Mr. Erskine-Smith was talking about, whether it would do what it is that...
I'm happy to hear, I'm happy to hear a more detailed explanation. And look, if I've got the comfort that this doesn't affect the change and it's the other amendment that affects the change I want, I'm happy to move on to the other one. But it would be good, just based on the fact that I'm not the expert in the room here, and it's based on other counsel who have suggested that I should put both forward. I would welcome a more detailed explanation.
Thank you.
Ms. Dewan, please go ahead.
I can try to provide that for you. So as the amendment is drafted, it proposes to remove mention of paragraph 3(1)(c)(1) from two places where it appears in clause 1 sub 8 of the bill. Paragraph 3(1)(c)(1), which it is proposing to remove, describes...
No,
Oh, I'm
that's
looking
not the
at the wrong
amendment.
one, sorry.
That's not the amendment we're talking
Okay,
about.
I can still explain.
The amendment we're talking about is the one that effectively says subsection 3, subsection 3
Yes.
does not apply
Yes.
to internationally adopted kids. Right, okay.
Yep. So what this amendment would do is it adds a new subsection to the Act that appears to have intended to exclude parents who were themselves adopted from being affected by the first generation limit, which is described in subsection 3 sub 3 of the Act. in cases where their adoption was recognized by the province or territory in which their adoptive parent resides or was in accordance with the Hague Convention. However, as currently drafted, the amendment would not have an effect because it cannot apply to anyone. Subsection 3.3, as amended by Bill C3, refers only and specifically to persons described under paragraph 3.1b, which is people who were born outside of Canada. The proposed amendment specifies that it would only affect or refer to a person, quote, a person who, while a minor child, was adopted as a citizen. So the reason why this is contradictory is any person who was adopted as a minor child and became a citizen cannot, by definition, be described in 3.1b of the Citizenship Act. Those people are described, if adopted and they get the 5.1 grant, as citizens under 3.1c.1. Or, if they naturalize and get a regular minor grant of citizenship, they're described under Section 3.1c. So adopted people can be either 3.1c.1s, or they can be 3.1cs. But the amendment as drafted only affects subparagraph 3.3, which only refers to 3.1bs. So if the paragraph only refers to 3.1bs, and adopted people are only 3.1c.1s, the two do not connect. Therefore, the amendment does not refer to any specific person who could be affected by it. That is why it is of no effect.
Mr. Erskine, so thank you so much, Ms. Dewan. Mr. Erskine-Smith, as we've heard that if the amendment were to move forward, so we could do one of two things right now.
Look,
we could either
all,
go
all
to
I care
vote.
about is the substantive change here, right? Like it doesn't matter to me how it's drafted. It doesn't matter to me how it's affected, so long as folks who are
so
adopted
unfortunately,
internationally.
Mr. Erskine-Smith, right now it's either we make a decision, either you withdraw this amendment or we actually go to vote.
I'm happy to withdraw it so long as I have clarity that, and I would welcome the view of officials, that if this is withdrawn.
So hold on, point of order, Mr. Erskine-Smith.
So we have a non-member of our committee essentially wasting our time on something he should be doing his own research. So I'd like to move on because we'd like to get through this today. We honestly want to get through this today.
Yes, okay.
So,
Mr. Erskine-Smith. So, Mr. Fragiscatos, and then we'll have to make a decision, please.
Yes, Mr. Erskine-Smith is not a full member of the committee, but he is subbing in, and he is an elected member of Parliament with full right to put forward an amendment. So perhaps, Madam Chair, it would make sense. Now, if Mr. Erskine-Smith wants to withdraw his amendment because of what we've heard, that's his choice. But perhaps it would make sense to understand which of Mr. Erskine-Smith's amendments has an actual effect, is not redundant.
Point of order. Point of order.
Point of order.
But,
Sorry, who's indicated point of order?
I'm not done speaking, Madam Chair.
There was another point of order on top of the point of order.
That would be the way to understand the best course forward, rather than what we're doing now.
So it's not a point of order, Mr. Fragiscatos, Mr. Metagakis.
Madam Chair, I think you said it correctly. Either Mr. Erskine-Smith withdraws or we go to a vote. There's no negotiation here about further amendments that he may want to have and how they impact. We're discussing this specific amendment. We want to move on with the work of the committee. So I think we should just call the vote, as it appears that Mr. Erskine-Smith is not willing to withdraw this unless he gets some kind of negotiation about his other amendments. That's not how committees work.
Thank you, Mr. Metagakis. Mr. Erskine-Smith, would you like to take this to a vote?
Yeah,
or
look,
withdraw?
this kind of goes back to Alexi's question, which is how many people does this touch? And this amendment, we're told, doesn't touch anyone. And then Ms. Huang, you went on to say subsequent amendment, I think it was Lib 4, affects the change and affects around 2,000 people over the last 5 years. So look, if the advice from officials is that this particular amendment doesn't affect the change, and contrary to the lawyer's view who I consulted, look, that's fine by me. I'm happy to withdraw the amendment, and we can proceed with the exact same debate when we get to Lib 4. I'm fine with that.
Okay. Thank you, Mr. Erskine-Smith. I need unanimous consent to withdraw the amendment. Do I have that? Yes. Okay. Thank you. All right. Next, we are on to the new version of CPC 2, which for our interpreters, it is version 136.35396. And I'll say it again, 136.35396. CPC 2. Who would like to speak to this motion? Ms. Rempel-Garner.
Thank you. Okay. So colleagues, you will have received this via email, and I do have printed copies in both official languages at the front if you need them. So I move that in Bill C3 in Clause 1, I move that Bill C3 in Clause 1 be amended by adding after line 28 on page 4 the following. 3.1, paragraph 1B does not apply to a person born outside of Canada on or after the day on which an act to amend the Citizenship Act 2025 comes into force if the person A is 18 years of age or more, but less than 55 years of age and does not have an adequate knowledge of one of the official languages of Canada. B is 18 years of age or more, but less than 55 years of age and does not have an adequate knowledge of Canada and of the responsibilities and privileges of citizenship as demonstrated in one of the official languages of Canada. Or C is 18 years of age or more and has not undergone a security assessment to determine whether they would be inadmissible under any of sections 34 to 37 of the Immigration and Refugee Protection Act. So colleagues, much like the amendments that I moved earlier, these provisions would put the provisions of C3, somebody obtaining citizenship through the provisions in in C3 through the same provisions that they would require to obtain citizenship by naturalization. And again, this speaks to the value of Canadian citizenship. So first, anybody obtaining citizenship through the provisions in Bill C3 should have an adequate knowledge of one of Canada's official languages. This is, again, this is language that's lifted directly out of the Citizenship Act. To me, one of the responsibilities of citizenship is being able to communicate in one of Canada's official languages. So this makes sense to me to align it with the Citizenship Act. The language in B is the language that's also in the Citizenship Act with regard to a requirement of a citizenship test. It seems unfair to me that somebody obtaining citizenship through Bill C3 would not have to go through the same process of citizenship tests that somebody obtaining citizenship through naturalization would go through. And then C is the same security requirements that would go through that somebody obtaining citizenship through naturalization would go through. So the intent of this amendment is to harmonize the provisions of C3 with the provisions that are currently in the Citizenship Act in order to preserve the value of Canadian citizenship. Thank you.
Thank you, Ms. Rempel-Garner. Debate. Ms. Zaid.
Thank you, Chair. Just some concerns I would have with this amendment is that I worry about the intent of some of these conservative amendments, which seem to seek to add conditions to birthright citizens. So this bill, is talking about citizenship. It is not about immigration. Some birthright citizens would be subjected to language tests or knowledge tests or have other conditions placed on their citizenship, while others do not. We are not talking about immigration here, so we are talking about the people born Canadians to Canadians. It is unfair to have conditions placed on what should be their birthright. This seems to be a return of two tiers of Canadians. The Conservatives tried to create that, was soundly rejected by Canadians back in 2015. And to quote a former Prime Minister, a Canadian is a Canadian is a Canadian. So I would really ask the officials to speak about to the consequences of creating different classes of Canadians or two tiers of Canadian citizenship. So if the officials can talk about it.
Who would like to do so? Ms. Wong. Thank you.
So as you are well aware, Bill C3 is about Canadian citizens by descent, and they are born Canadian. So they derive their status from their Canadian parent. And these people are Canadian, they become citizens at the moment of their birth, automatically by operation of law. So imposing language proficiency and knowledge requirements as well as security requirements as conditions of either acquiring or maintaining, retaining their citizenship status as proposed by this amendment would be impossible to operationalize, as such status is conferred by operational law at the moment of their birth. Furthermore, there is, from a technical perspective, there is reference to inadmissibilities in IRPA, which under the Citizenship Act, we do not have IRPA sections. We have our own prohibitions that are different from inadmissibilities because IRPA is about foreign nationals, while Citizenship Act is about people acquiring citizenship. So in addition to the impossibility of being able to operationalize these requirements, it could lead us down a path of actually creating more lost Canadians, which is the reason why we're here today. The bill is to restore citizenship to lost Canadians, and with this type of requirement, we could potentially create another cohort of lost Canadians.
Thank you, Ms. Wang. We have Mr. Fragiscatos.
In fact, I think the point has been dealt with. I wanted to ask about basically the same question that Ms. Saeed said, so we're fine.
Ms. Rempel-Garner.
I just wanted to tell colleagues that we will have amendments, another amendment later, which will address some of the operationalization components of this. So I don't think it's not. I think impossible is the wrong word.
But do you have an amendment to this amendment, or do you just want to? Okay.
No, it's in order.
All righty. So, any other debate or on this? If Mr. Fragiscatos.
So, is the Conservative position then that they understand that this amendment's problematic, but they will support it anyway because there's another one coming that will fix it? Why not just fix it now?
Does anybody want to respond to that? Okay. Any other further debate? Ms. Zaid.
So my question, like same on what my colleague MP Fragiscatos said, that like does the Conservatives think that yes, really with these amendments, it will create two tiers of citizenship, and Canadian is a Canadian will not imply? That's why they want to bring some amendments to it?
So, Ms. Zaid, you're asking that of our Conservative colleagues? Okay. Does anybody want to respond to that? Okay. Any other debate? If not, then shall CPC 2 carry, which is the new version 136.35396? Shall we have a vote? Yes, a vote, Mr. Clerk.
So CPC 2, Mr. Fragiscatos.
No.
Ms. Zodi.
No.
Ms. Zaid.
No.
Monsieur Zuberi.
No.
Mr. Ma. Mr. Minigakis.
Yes.
Mr. Ridicop.
Yes.
Ms. Rempel-Garner.
Yes.
Monsieur Brunel-Duceppe. Yeas 5, nays 4.
Okay, the amendment carries. Now, shall clause 1 as amended carry? Shall we go to a vote? So, I'll give everyone a minute to take a peek. Clause 1 as amended. Yes. Okay. Shall clause 1 as amended carry? Okay. Shall we have a recorded vote? Record a vote, please.
So the vote is on clause 1 as amended. Mr. Fragiscatos.
No.
Ms. Sodi.
No.
Ms. Zaid.
No.
Monsieur Zuberi. No. Mr. Ma. Mr. Minigakis.
Yes.
Mr. Ridicop.
Yes.
Ms. Rempel-Garner.
Yes.
Monsieur Brunel-Duceppe. Yeas pour 5, 5, nays contre 4. 4.
The amendment carries. Thank you. The clause carry, sorry. Okay. Shall clause 2 carry? Just gather a moment to make sure everybody knows what we're talking about. Shall clause 2 carry? On division, is that okay? On division? Okay. Clause 2 carries on division. Shall clause 3 carry? On division? On division? Clause 3 carries on division.
So you can call clause 4, and then you can say we're on clause 4.
So we are on clause 4.
And then Ms. Rempel-Garner has an amendment.
I believe that Ms. Rempel-Garner has an amendment. I believe it is, yes, CPC 3. And for our interpreters, it's 136197959. Sorry. I just want to make sure that they know what we're talking about. CPC 3. Yes, Ms. Garner, Rempel-Garner, do you want to speak to it, or does Mr. Reddekopp do?
He can move it, right?
Okay. Yes, Mr. Reddekopp, please.
Yeah.
Thank you, Chair. So I move the following, that Bill C3 in Clause 4 be amended, A, by replacing line 6 on page 7 with the following, quote, at least 1,095 days during any period of 5 consecutive years before the person's adoption, or B, by replacing line 16 on page 7 with the following, at least 1,095 days during any period of 5 consecutive years before the person's adoption. So this motion is basically the same as we just did in CPC 1, just to make it consistent between the adoption side and the born outside of the country side. So we've talked about it, I don't have much more to say than that. It's just to keep it consistent with the rest of it.
Thank you. Debate? Mr. Fragiskatos.
Just a question to officials. I would assume that your concern raised earlier holds here as well.
Yes.
Thank you, Mr. Fragiskatos. Anyone else? Monsieur Brunel-Duceppe, do you have wise words here? No? Okay. Okay, shall CPC 3 carry? Vote or vote? Please record a vote. Mr. Clerk.
CPC 3, Mr. Fragiskatos?
No.
Ms. Sodi?
No.
Ms. Zaid?
No.
Monsieur Zubiri?
No.
Mr. Ma? Mr. Minigakis?
Yes.
Mr. Reddekopp?
Yes.
Ms. Rempel-Garner?
Yes.
Monsieur Brunel-Duceppe? Yeas pour 5, nays contre 4. 4.
Okay, CPC 3 carries. Thank you. Next, we are going to Lib 4. Shall Lib 4 carry?
You will need to move it first.
Lib 4, I believe that Mr. Erskine Smith would like to move it first.
Okay, here we go again. Deja vu. This, as previously debated, I'll just move and we'll get into it. But Bill C3 in Clause 4 be amended by adding after line 16 on page 7 the following, 4.1, subsection 4 does not apply in respect of a person who, while a minor child was adopted before or after the day on which an act to amend the Citizenship Act came into force, by a citizen if the adoption is recognized by the province or territory in which the adoptive parent resides and was in accordance with the Convention on the Protection of Children and Cooperation in respect of Inter-Country Adoption that was concluded on May 29, 1993 and came into force on May 1st, 1995.
Thank you. Mr. Smith, do you want to speak to it?
I just want to pick up where we left off with Alexi's question because I just want to make sure I've got this absolutely clear in my mind. The problem that I articulated in my initial remarks, the problem I'm aiming to solve is not in relation to kids who are adopted. 5.4 speaks to kids who are, 5.1 sub 4 speaks to kids who are adopted, and that's fair. But the problem I'm trying to solve here is those then adopted kids, when they have kids outside of the country, are treated differently, and so. Just to be crystal clear here, this amendment will solve that problem. An adopted kid, internationally adopted, your advice before was my previous amendment would have no effect, but the problem, as I articulated, the problem I'm trying to solve is a kid who's adopted through an inter-country adoption becomes a citizen of Canada through direct grant, and then themselves has a kid elsewhere, right? So not adopts a kid elsewhere, but themselves has a kid elsewhere, they are going to be able to pass their citizenship on directly if this amendment is passed. Is that the advice? Right. I see a head shaking, and that's my concern. So anyway, if you could answer that question, please.
Ms. Huang.
Perhaps what I could do is just give you our interpretation of what.
No. I want an answer to that specific question.
Mr. Erskine-Smith, let's have.
I don't want an interpretation of this. I have a specific problem I was aiming to solve. My previous amendment was aiming to solve that as well. I want an answer as to whether this amendment solves that specific problem in your view, because you said previously the amendment would affect no people, and this amendment would affect people. But just so we're crystal clear, what I'm aiming to solve is someone who's adopted through an intercountry process as a Canadian citizen through direct grant, and then themselves has a child abroad, if they're going to then not be subject to the substantial connection test if this amendment passes.
Is there anyone who can respond to that? Ms. Dewan.
Thank you for the question, Madam Chair. I can speak to what our analysis of this amendment, what the effect would be. This amendment as drafted will have the effect of allowing adopted children to access the 5.1 grant, irrespective of the generation of the adoptive parent, if the parent was also adopted and granted under 5.1. It will not make it possible for an adopted person to pass on their citizenship by descent to a child born abroad. In other words,
hold on, let her finish. Thank you.
Sorry. Prospective adoptive parents, if they themselves were adopted, will not be subject to the first generation limit at all, and therefore not the substantial connection requirement, and will be treated the same as if they were born or naturalized in Canada for the purposes of accessing the 5.1 grant for future children adopted abroad.
I understand that because it's relation to adopted children, but now your previous advice was that the previous amendment would affect nobody. It was of no force and effect, effectively. That was your advice to parliamentarians across the aisle and myself. But Nathaniel, not me, the example kid from Zambia, if this amendment doesn't actually solve the problem of him having a kid abroad, so he is going to be treated differently. Whereas now, that previous amendment, where you told me that it would have no force and effect, wouldn't that have solved that problem so he could have passed that citizenship on directly?
Is there anybody who wants to respond to that? Ms. Huang?
Again, all I can say is we have analyzed the previous amendment as when you had tabled it, and it is our view that it has no effect. This amendment, however, is doing something different, so we can speak to this amendment, but the previous amendment did not have any effect.
Sorry, so Ms. Dewan, you just said, and correctly, that this would apply to adopted kids. So if, for example, you have someone subject to an intercountry adoption who then goes on to adopt, right? Which is why I actually changed from or to and, to make sure that there's always that real and substantial connection to a provincial or territorial agency and residence here in Canada. So real and substantial connection is then built into the process. My concern, though, is I feel absolutely misled because the previous amendment would have actually affected a change such that someone who is adopted through an intercountry adoption would have then not been subject to the real and substantial connection test if they had themselves a kid abroad. Tell me I'm wrong.
Is there anybody that wants to respond to that? Ms. Dewan.
Thank you for the question. I cannot answer your hypothetical.
Mr. Erskine-Smith.
There was an amendment on the table, and you gave advice that appears to be incorrect
kindly allow
advice.
the witness to answer. Sorry, not the witness, but our officials to answer.
The amendment that was previously tabled did not have an effect because of the provision of the act that it was proposing to amend. It is possible to amend the act in such a way that you could achieve the effect you seek to achieve, but not through the previous amendment. Thank you.
Thank you.
I just have one last question, Chair, and then I will leave it alone. But the amendment to this section specifically speaks to kids who are adopted abroad, and you've told me that it affects a change. The previous amendment spoke to kids born abroad, and the exact same language affecting the exact same change And honestly, it would have, I feel entirely misled at this point because it would have affected that child who, growing up and has a kid abroad, would then not have been subject to the substantial connection test had that previous amendment passed. So it would have actually affected real life people. Anyway, we're not going back. I don't expect I'm going to get unanimous consent. I expect this will get litigated again. But I don't even know what to say about the advice you previously gave this committee.
Erskine Smith, and thank you, officials, for that. Is there any other debate? Okay. Shall Liberal 4 carry? Shall we do vote? Vote, Mr. Clerk.
The vote is on the amendment Lib 4. Mr. Fagin-Status? Sorry, Fagin-Status.
Yes.
Yes. Ms. Sodi?
Yes.
Ms. Zaid? Oh, no, I'm sorry. Erskine, sorry.
Yes.
Mr. Zubiri? Monsieur Zubiri?
Yes.
Mr. Ma?
No.
Mr. Minigakis?
No.
Mr. Ridicop?
No.
Ms. Rempel-Garner?
No.
Monsieur Bounet-Duceppe? No. Yeas pour 4, nays contre 5.
The amendment does not carry. We are now moving on to the new version of CPC 4, which, just for interpreters, is 136-35995. So 136-35995. Nope. According to what is in front of me, I have 136-35995. I will double check with my legislative clerk. Oh, 998. Sorry, she has, sorry, it's 998. I apologize. I'll read it out one more time. Newer version of CPC 4, 136-35998.
Bingo.
Okay, sorry about it. Sorry, Ms. Rempel-Garner, please go ahead. Oh, Mr. Redcott.
Thank you, Madam Chair. So I move the following, that Bill C3 in Clause 4 be amended by adding after line 16 on page 7 the following. 4.1, no person who is adopted on or after the day on which an act to amend the Citizenship Act 2025 comes into force may be granted citizenship under any of subsections 1 to 3 if the person A is 18 years of age or more but less than 55 years of age at the date of his or her application and does not have an adequate knowledge of one of the official languages of Canada. B is 18 years of age or more but less than 55 years of age at the date of his or her application and does not have an adequate knowledge of Canada and of the responsibilities and privileges of citizenship as demonstrated in one of the official languages of Canada. Or C is 18 years of age or more and has not undergone a security assessment to determine whether or not they would be inadmissible under any of sections 34 to 37 of the Immigration and Refugee Protection Act. So once again, this is just a duplication of what we discussed previously. I'm sure all the previous comments would just carry over to here, and I just would move that we go to a vote.
Thank you. Yes, Mr. Fragis-Gatos.
I'll just, for the record, ask officials to put their view on the record.
So as drafted, this amendment appears to cause the testing and assessment requirements to apply to all those who access the 5.1 adoptions grant in the first generation and beyond, so not just after the first generation. So the new subsection would have the effect of, in order to access the direct grant of citizenship for adoptees under Section 5.1 of the Act, persons age 18 to 54 for the first two requirements, language and knowledge, and anyone 18 or older for security clearances. So on or after, born on or after, adopted on or after the Bill C3 is in force, would be required to demonstrate adequate knowledge of one of the official languages of Canada, demonstrate adequate knowledge of Canada and one of the responsibilities and of the responsibilities and privileges of citizenship as demonstrated in one of the official languages of Canada, or undergo a security assessment to determine whether or not they would be inadmissible under any of the sections 34 to 37 of the Immigration and Refugee Protection Act. So I would say similar concerns from the perspective of while this is a grant, so it is different. In the previous amendment was applying to children born abroad in the first generation and beyond who are citizens from birth. This one would be applying in a grant context where they do have to come forward to seek a grant, and part of that grant, there are criteria that have to be met, and this proposed amendment is introducing additional criteria that would have to be met in order to be granted citizenship. Similarly, the same concern as we had mentioned earlier, it is introducing sections 34 to 37 in IRPA, which in the Citizenship Act, there is no reference to inadmissibilities. It is referring to prohibition, so whether or not someone would be prohibited to obtain citizenship. So it is introducing, linking the two acts together.
Thank you, Ms. Wong. Anyone else? Any other questions? If not, we will go to vote. Shall CPC 4 carry? Mr. Clerk.
CPC 4, Mr. Fragiskatos.
No.
Ms. Sodi.
No.
Ms. Zaid.
No.
Monsieur Zuberi.
No.
Mr. Ma. Mr. Minigakis.
Yes.
Mr. Riddick.
Yes.
Ms. Rempel Garner.
Yes.
Monsieur Brunet-Duceppe. Yeas pour 5, nays contre 4.
Thank you, Mr. Clerk. CPC 4 carries. Next, shall clause 4 as amended carry? Who would like to speak to it, if anyone? Or just vote? I think we could just go straight to vote. Mr. Clerk.
So clause 4 as amended. Mr. Fragiskatos.
Yes.
Ms. Sodi.
Yes.
Ms. Zaid.
We.
Monsieur Zuberi.
Yes.
Mr. Ma. Mr. Minigakis.
Yes.
Mr. Riddick.
Yes.
Ms. Rempel Garner.
Yes.
Monsieur Brunet-Duceppe. Carried.
Clause 4 as amended carries. Thank you. Shall clause 5 carry? Oh. Sorry. Clause 4 as amended carries. Thank you. Shall clause 5 carry? Mr. Redekop.
We have CPC 5, which I believe is in clause 5. After.
We have that in the new clause afterwards, so
Okay.
after this.
Okay.
Is that okay? That's according to my recommendation of our legislative clerk. We do this clause 5, and then the new clause comes up.
So there's no amendments in clause 5?
Okay.
Yeah.
Okay. So right now, it's clause 5. I just want to make sure everybody is aware of which clause we're talking to. Mr. Fragiskatos, you have a question?
I was going to say there's no amendments in clause 5? Okay, just to be clear.
No. Okay. Shall clause 5 carry? On division? Alexi? On division? Clause 5? You look troubled.
Oui, ben, je croyais qu'il y avait un amendement des conservateurs.
I thought there was a conservative amendment to clause 5. Okay.
Monsieur Brunel-Duceppe, okay. So clause 5 carries on division. Okay, now we have a new clause, CPC 5, and that's a number?
Yep.
Okay, so it's for our interpreters, 136-20196. Who would like to speak to it? Mr. Redekop.
Thank you, Madam Chair. So we have concerns about the ability, the transparency, and having some numbers. And so I make the following motion. That Bill C3 be amended by adding, after line 2 on page 8, the following new clause. 5.1, the Act is amended by adding the following after Section 26. 26.11, within 3 months after the end of each fiscal year, the minister must prepare a report for the previous year that sets out the number of persons who became citizens as a result of the coming into force of
Point d'ordre, Madame la Présidente. On va donner une chance à...
Point of order. Let's give the interpreters a chance. Start over because they didn't have the right document for those listening to us. The millions of people listening to us.
C5, again, it is 136-20196. Okay. So just wait a second and then,
Get the thumbs up from the interpreters
okay.
first.
Thank you. Okay, Mr. Redekop, I got it.
Do we? Okay, all right, here we go. So I move the following. That Bill C3 be amended by adding after line 2 on page 8 the following new clause. 5.1, the Act is amended by adding the following after section 26. 26.11, within 3 months after the end of each fiscal year, the minister must prepare a report for the previous year that sets out the number of persons who became citizens as a result of the coming into force of an act to amend the Citizenship Act 2025, their countries of citizenship other than Canada, if any, their most recent country of residence, and the provisions of this act under which they are citizens. 2, the minister shall cause the report to be laid before the House of Parliament on any of the first 15 days on which that House is sitting after the report is completed. So, this is about accountability, it's about transparency, just so that we have a sense, so the Parliament and the people of Canada have a sense of how many people have been affected by these changes. We think it's important that that information is made public. We asked just today a numbers question on a different issue, and so they're common things that are asked and required. And so we feel that this would be very helpful information and should be something that could be doable by the department. Thank you.
Thank you, Mr. Redekop. Anybody want to comment on this? Mr. Fragiscatos.
It's to officials, obviously. If there's concerns or objections, please put them on the record.
So again, just want to emphasize that Bill C3 is about Canadian citizens by descent, and they are born Canadian. And the government of Canada has not tracked births abroad since 1977. As such, it's not possible to accurately state how many persons will, through operation of law, become citizens as a result of the bill. Further, not all individuals who become citizens as a result of the bill will seek a certificate of citizenship known as the proof of citizenship. So introducing this reporting requirement would require the government to implement a mechanism for Canadian citizens to register the birth of their children outside of Canada, which will place an additional burden on Canadians and the government. However, unless such a registration or some other interaction with the department with respect to this cohort is mandatory, the data collected by IRCC would not be accurate when we table such a report. In the case of adoptees, because they come forward to seek a grant of citizenship of 5.1, that is something we could report on because there is an application process and they do come forward and we have a record of that.
Thank you, Ms. Huang. Any other questions or comments? Okay. Shall CPC 5 carry? Sorry, yes, CPC 5 carry. Yes. Vote, Mr. Clerk.
Yes, Mr. Fragiscatos?
No.
Ms. Soudi?
No.
Ms. Zaid?
No.
Monsieur Zubiri?
No.
Mr. Ma?
Yes.
Mr. Minigakis?
Yes.
Mr. Redekop?
Yes.
Ms. Rampel-Garner?
Yes.
Monsieur Boutin-Duceppe? Yeas pour 5, nays contre 4. 4.
Okay. Clause CPC 5 carries. Thank you. Now we are on Clause 6. Who would like to speak to CPC 6? Okay, Mr. Redekop.
Thank you, Madam Chair. Now, this gets back to what my colleague...
Just point of order. Sorry to cut my colleague off. We are on reference number 1362-7040.
Okay, we have the thumbs up. Perfect. So this is in relation to what my colleague, Ms. Rampel-Garner, spoke about. There are some operational things that need to be done, and this is one of the things that is required. And so I move the following. Subsection 27.1 of the Act is amended by adding the following after paragraph C. C.01. Respecting the length of physical presence in Canada required under subparagraphs 3.3a-II, 3.3b-II, 5.14a-II, and 5.14b-II, including the manner of calculating the length of physical presence, any documents required to demonstrate that a person meets the requirement and the circumstances in which the requirement does not apply. So again, this is to give the department some ability to get documentation and to be able to actually operationalize some of the other things that we've asked for in here. Thank you.
Thank you, Mr. Redekop. Anyone else? Mr. Fragiskatos.
Just to get officials to put their view on the record.
There would be 4 points that I would make for this proposed amendment. Given that length of time is a significant factor in how the bill, in shaping the bill, it is something that would normally be put in the Citizenship Act and legislated, and not that it would be put in the regulations. The second point is that it would be redundant to have it in two places. So the proposed amendment, you would have it in the Act, but you would also have it in regulations. And the third point is that there's already a regulation making authority in the Act to define the information and evidence that would be required for us to assess the substantial connection requirement. And I would just like to point out that the department already does this on a regular basis for various lines of businesses, from assessing permanent residency status to assessing the grant of citizenship, whereby they have to meet 1,095 days within the last 5 years. We also do this through the interim measure, whereby they have to, for those born on and after December 19, 2003, they would have to demonstrate a substantial connection to Canada, 1,095 days. So the department already has a lot of experience and is doing this already, and we have processes in place. So the last point is that by putting this into the regulations versus operational guidance would make it quite restrictive in terms of giving us the flexibility to assess the requirement.
Swang. Okay. If there's no other comments, shall CPC 6 carry? Mr. Clerk.
Mr. Fragiskatos.
No.
Ms. Sodi.
No.
Ms. Zaid.
No.
Monsieur Zubiri.
No.
Mr. Ma. Mr. Minigakis.
Yes.
Mr. Redekop.
Yes.
Ms. Rampel-Garner.
Yes.
Monsieur Bounet-Duceppe.
Oui.
Yeas pour 5, nays contre 4.
Then CPC 6 carries. Thank you, Mr. Clerk. Next we go to Clause 6 as amended. Shall Clause 6 as amended carry? Mr. Clerk. On division?
Oh, no, we'll do a vote.
Vote. Okay. Mr. Clerk. Wrestling his papers. Trying to look cool, calm, collected. Okay.
Okay, so Clause 6, right?
Yes.
Okay.
It's Clause 6 as amended.
Okay. So, Mr. Fragiskatos?
Yes.
Yes. Ms. Sodi?
Yes.
Ms. Zaid, I'm sorry?
Yes.
Monsieur Zubiri? Mr.
Oui.
Ma?
Yes.
Mr. Minigakis?
Yes.
Mr. Redekop?
Yes.
Ms. Rampel-Garner?
Yes.
Monsieur Bounet-Duceppe?
Oui.
Carried.
Thank you. Thank you. Clause 6 as amended has carried. Okay, on to CPC 7. Who would like to introduce that? Mr. Redekop.
Thank you, Madam Chair. I move the following, that Bill C3 be amended by adding after line 13 on page 8 the following new clause. 6.1, the Act is amended by adding the following after Section 27. 27.011. Within 3 months after the end of each fiscal year, the Minister must prepare a report from the previous year that sets out the number of persons in respect of whom the requirement to undergo a security assessment under paragraphs 3.1c or 5.1, 4.1c was waived, and the reasons for which it was waived. 2, the Minister must cause the report to be laid before each House of Parliament on any of the first 15 days on which that House is sitting after the report is completed. So once again, this is about transparency, and in particular, this is about granting citizenship by exemption to the security screening, including the amount of exemptions and the reasons used. We think it's important for Parliament to know how the minister is using the powers that they have, and this should accomplish that. Thank you.
Thank you, Mr. Redekop. Mr. Fragiscatos.
Yes, if officials could put their view on the record.
The two previous substantive amendments, which I know you changed, so I don't have the exact number, but the ones related to security assessments for both those born abroad in the first generation, plus those who access the direct grant of adoption 5.1 in the first generation. The way it is written, it seeks to add these grounds to undergo a security assessment. They do not set out any authority to waive inadmissibilities. So the purpose of this amendment, in other words, to require a report on the number of times these inadmissibilities have been waived and the reasons for their waiver, appears to be moot.
Thank you, Ms. Wong. If there's no further comments, then let's go to a vote. Shall CPC 7 carry? Mr. Clerk.
Mr. Fragiscatos?
No.
Ms. Sodi?
No.
Ms. Said?
No.
Monsieur Zubiri?
No.
Mr. Ma?
Yes.
Mr. Minigakis?
Yes.
Mr. Redekop?
Yes.
Ms. Rampel-Garner?
Yes.
Monsieur Benedusep?
Oui.
Yeas pour 5, nays contre 4. 4.
Thank you, Mr. Clerk. CPC 7 carries. Next, we are going to Clause 7. Shall Clause 7 carry? Clause 7 shall. On division? On division? Yes, on division. Clause 7 carries on division. Okay, good job. Now we move on to the title. Shall the title carry, which is the current title is an act to amend the Canadian, an act to amend the Citizenship Act 2025. Shall the title carry?
Yes.
On division? On division, Alexi, I need to see your eyes. Shall the title carry on division?
Sorry.
Thank you. Shall the bill as amended carry? On division, Alexi, yes, thank you. Shall the chair report the bill as amended to the House? Yes. Okay, on division, thank you. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Okay, so I will take that on division as well. Thank you. I do want to take a chance to say thank you to the officials. Thank you. Thank you for your patience. Thank you for answering questions. Thank you for being here today, and thank you for all your hard work. Thank you. I think that takes us right to the end of our time. And so as there's nothing else on the agenda, this meeting is adjourned.